The LP is attached. The court will take judicial notice of the court file and note for the record that both parties are present today, that there was citation issued that was actually served on both parties. The mother was served back in, looks like, she was served in September 2023, and that's been back on file for X amount of time. Here's that Mr. Strong was served with citation back on December the 9th, 2024. However, this citation has not been returned, is not in the court file at this point. So, but the court
Back-end index pointing right. Right away, you can feel the tension building. Paperwork problems in court are never small. Missing filings can literally change how fast or slow justice moves.
will know for the record that both parties are present. So at this time, I ask the state for an opening to tell the court what the state's request that we do here, and whether or not we can proceed at this time based on the fact that the citation has not been back on file the direct amount of time. Thank you.
The state is hoping to proceed and, if possible, get a temporary order. The state understands that this to be a fairly contested case. There are matters of retroactive that are contested. I believe the non-custodial parent will advise that he has some form of documentation he can provide to show payments or support that he's provided over the years, but he does not currently have access to that as he is currently driving for work. And then state also understands that the non-custodial parent wishes to challenge the AOP or have some time to seek legal counsel in order to do so.
All right, then. Well, we can definitely proceed. It sounds like we're going to get past the temporary hearing anyway today, so we can definitely proceed on that based on what the state's saying or at contact at this time. Let's go ahead and get the parties on the record and see what they're specifically requesting. And at best, we may we'll come up with a temporary order and reserve all the other issues concerning retro and give everybody get a chance to get all their ducks in a row as far as be able to get the information before the court. But let's see how far we can get today, and then we'll look out to see what date the court might look at as far as a reset for a final contested hearing, giving everybody the right to go seek legal counsel if they wish. So at this time, Mr. Gwen, I'll go ahead and swear the parties in, and let's go ahead and start this as a temporary hearing, and let's see how far we're going to get today. So at this time, Ms. Thornburg and Mr. Strong, please both unmute yourselves and raise your right hands, please. Do you both solemnly swear or affirm your testimony going to give you the days of truth, the whole truth, and nothing but the truth shall help you?
Yes, Your Honor.
Back-end index pointing right. Notice how the judge keeps stressing documentation. In family court, feelings matter, but paperwork decides outcomes.
I do.
All right, you can put down your hands. You're both officially under oath. I'm going to go ahead and let the state call you both as witnesses. Obviously, for right now, Mr. Strong, the only thing I can go with are the four corners of the documentation I have in this court file. Court file is a request at this time for establishing paternity legally, set up child support, so forth and so on. Anyway, the court's going to go ahead and ask you both questions at this time to see what we got, this in agreement and not in agreement, and then figure out what has to be set up for a final contested hearing at a later date. That will give both of you the opportunity to go seek your own legal counsel if you wish. So at this time, Mr. Gwen, they're both officially under oath, and you can go ahead and call your first witness. Thank you.
Well, thank you. State would like to call Michael Strong.
All right. Yes, sir.
Mr. Strong, please state your full name for the record.
My name is Michael Fitzgerald Strong Jr.
And what is the name of the child that we're here on?
Harmony Nevaeh Strong.
When was Harmony born?
October 7th, 2014.
How many other children that are currently born or have been born do you have?
How many kids do I have? 6.
And how many of those children are currently still under the age of 18 or minors?
5.
I'm sorry, you said 5?
5. Yes, sir.
And how is the child that we're here on, how is Harmony receiving medical coverage?
I couldn't tell you.
Okay.
I do
How much do
not
you
know.
make a month? How much do you
How
make
much
in
do I make a month?
Yes.
It varies, like I told the guy earlier. He put, I believe he
What
said
on average?
3,000 down.
How would you say? How much would you say?
Like I explained to him, it's levels to it. If you just say entry, just say 3,000. I
Okay.
couldn't really
So
just.
you make about
We have
3,000.
numbers we have to meet. Yeah. Yes, sir.
Just a second, sir. Where are you currently working?
I do pest control, turn defense pest control, sir.
And how long have you been working there, sir?
2.5 years.
All right, so you got you got a W-2 for 2025, correct, sir?
Yes, I do.
All right. Did you part of the discovery in your case was you're supposed to submit your last 2 years of W-2s? Did you submit to the state the 2025 W-2?
Have I like filed for this year for 25?
Then I'll ask, did you actually submit a copy to the state of Texas, the AG's office, of a copy of your current W-2 for 2025?
No, I haven't done any of that yet. I haven't. I'm here today because I want a DNA test.
I'm sorry,
That's all I want right now.
Stop. Here's the deal, sir. This is a court of law. You don't get to go off on variances until, and you'll get the opportunity to tell the court what you're requesting to do at this time. But I'm asking the questions at this point. And I know you're not a lawyer, sir, but when you got served with a copy of that paperwork, it asks for, in the request for productions, bank records and W-2s. And the W-2 is, if that's your only source of income, is that W-2, and I'll have a state confirm that's your only source, to make sure you're not getting VA disability or something else like that. And that will, what you earned last year is going to control what the court does for child support going this year. So that's why I was asking about it. But this time, I'll go ahead and let the state proceed. And again, at the end of the hearing, sir, both you and the mother will have the opportunity to tell the court what you're requesting based on the fact that you're both your own legal representative at this time. So you may proceed at this point, Mr. Gwynn. Thank you.
Thank you, Judge. Mr. Strong, what, if any, disability payments are you receiving?
None.
What, if any, military retirements are you currently receiving?
None.
What is your source of income?
I'm full time.
Okay. That job is your only source of income?
Back-end index pointing right. Here comes the emotional turning point. The father isn't refusing responsibility. He's questioning certainty. And in paternity cases, DNA can flip everything.
Only thing I do, yes, sir.
And currently, you're testifying that you make about $3,000 a month doing that work?
Yes, sir.
What are you requesting the court do here today?
I just want a DNA test. The only reason I agree that parents should pay child support, but as I explained to the guy earlier, my daughter was coming up here. We had a great connection. The mom
Objection, non-responsive.
and I don't know why.
So here's the deal.
That's all that I want. I just want a
sir,
DNA test. I don't want no drama.
Sir, stop. Yes, sir. Don't have to explain why you want something. You just tell the court what you want, and it's my understanding that you're requesting the DNA test. Okay. State.
That's all I want. Yes, sir.
Next question. Thank you.
Why are you requesting a DNA test?
Just the way that we broke up, the way that things were, I just feel that's just what I believe. If I can't explain it, I just want a DNA test. I just feel like if I have to pay child support, which if I
Objection,
do, I
non-responsive.
just want to make sure she's mine.
Again, sir, you're explaining things again. I know you're not a lawyer, but you see enough lawyers.
I don't know what.
Yeah, the answer is you want to.
Okay, I don't know what he's asking.
And right now, the reason is you
Yeah, that's what I said.
Okay, we got it, sir. All right, you may proceed to the next question, Mr. Gwynn. All right,
There's no further questions of this witness at this time, Judge.
All right, go ahead and call your next witness and see if the mother's in objection to the DNA test or not, and we'll take it from there. Thank you.
Thank you, Judge. State would like to call Vanessa Thornburg.
I'm here.
Ms. Thornburg, how is Harmony receiving medical coverage at this time?
She receives Medicaid, sir.
All right. And what, if any, objections would you have at this time to DNA testing being conducted?
I mean, I don't mind a DNA test. I mean, I don't know if that's something that I need to say yes or no to, but I don't mind though.
Here's the deal, man. It would say right now, technically, y'all signed an announcement. Now it's more when in 2014.
She was born 2014. Yes, sir.
All right, I got a DNA. I got a acknowledgement paternity. Looks like from 2019, and technically that controls right now. With the court, based on how old this thing is and all that, I have the option to go ahead and order the DNA test, and obviously that would speed things along and probably save everybody a lot of money to not go and talk to an attorney. So, is there? But you say you're not in objection to it if I go ahead and order that at this point, correct, ma'am?
No objection to it, sir. I mean, I already know who her father.
Backhand index pointing right. This moment is huge. The judge is balancing law, cost, and fairness, trying to prevent both sides from wasting thousands in legal fees.
There is, but yes, sir.
Okay. All right, then. Thank you. All right, Mr. Gwynn, you can go ahead and proceed. If you want to, I can let them know what I'm thinking about doing at this point, Mr. Gwynn. I know I kind of shortchanged you right there, but you can go ahead and finish it with any other questions you have of Ms. Thornburg. Thank you.
State doesn't have any further questions of this witness at this time, Judge. Thank you.
All right, Ms. Thornburg, Mr. Strong, here's the deal. I got great latitude when I deal with this, and I do it all the time because, it's one of those things it's always considered to be in the child's best interest, and there's no doubt going forward as far as the circumstances of paternity are concerned. I can make everybody, I can play it like the law could allow me to do, deny that, go ahead and make everybody go out and hire a lawyer and make a lot of ill feelings because you got to go ahead and pay somebody $300 an hour to do something I can take care of here right now today and get it done. That's what I'm going to do.
Backhand index pointing right. And here's the reality check. DNA tests may seem stressful, but compared to long legal battles, they're often the fastest truth finder.
But however, Mr. Strong, that announcement paternity that's in the court file it controls. So what I'm going to go ahead and look at doing, and I'll have the state give me the math and everything, I'm looking at going ahead and doing a temporary order. I'm looking at setting up temporary child support, temporary cash medical support, and I'm looking at ordering temporary visitation if appropriate. I'll let the state get some details about that. It sounds like y'all may not be anywhere that close to each other as far as vicinity is concerned. But I will go ahead and order the DNA test, and we set this matter for a couple of months out. And at the end of the day, when we come back, Mr. Strong, if it turns out that DNA test comes positive, I have the absolute option of ordering you to pay the court costs on that DNA test. It's usually somewhere around $200 or $300, but it beats paying a lawyer $350 an hour and justify the paperwork to get the DNA test. So at this time, I'm going to start with you, Mr. Strong. Do you understand what I'm looking at doing, sir? You're muted, sir.
Yes, sir, I hear you.
All right. And do you have any disagreements with that, sir?
Do I need to, before you order this temporary order, I do pay child support for the kids. So can that be considered into this temporary order as well?
Yes, sir. The number of children you have under the age of 18 that you're legally obligated to support, it sounds like you got, I'm not sure if the 5 included this child or if it's 5 and 1 in and 4 out or whatever the number is. The correct percentage for figuring that child support amount out will be done by the state in calculating your temporary child support, sir. It's all about a percentage.
Okay,
If you have
cool.
4
Thank you.
1 child out, one child in and 4 out, it's going to be somewhere around that 15% of your net income is what you have to pay in child support. And I'll let the state confirm that.
Yes, sir.
Do the math.
All right. Thank you, sir.
Next, any other questions, sir?
No, sir, not at all.
All right, Miss Steinberg, any questions, ma'am? Then I'll let the state tell me if they have the math already done. Do you have any questions up to this point, ma'am?
Just out of curiosity, sir. I mean, 'cause like I said, I'm not aware of how the process works with this. I know as far as them speaking with him pertaining to how many children he does have, are we doing anything as far as to verify and making sure that these children he's stating that are his, that he's claiming?
He's going to verify that information, ma'am, and he's doing it under oath. So if he'll have to verify that information before final hearing, and so I usually order copies of any and all other court orders verifying, or if he's married and has a copy showing that there are children currently born into the marriage. But I'll let the state expand on that as necessary when they finish up asking questions as to both of you at this point. Thank you.
Okay. Yes, sir.
All right, so Mr. Gwen, you may go ahead and confirm that information with Mr. Strawn about the number of children he has and how they were set up to be found to be his, either through marriage or by court order. Thank you.
Yep, thank you, Judge. And actually, if the state could quickly recall Ms. Thornburg, I did have a handful of questions for her.
All right, you may do so. Thank you. Not a problem.
With regards to access and possession, what, if any, safety concerns do you have with Mr. Strawn?
I'm sorry. Can you repeat that? I didn't catch the beginning of that.
With regards to the access and possession of Harmony, what, if any, safety concerns do you have between her and Mr. Strawn?
Oh, I have no safety concerns at all, sir.
Okay. And when was the last time that child visited her father?
You got me thinking here now. I believe about the last time she went was about 2 summers ago.
Okay. How long does the child visit her father?
Well, she's only been out there twice. And so, like I said, it's only been, when she went out there was out for a couple of weeks. One was for Christmas break and she went during the summertime the second time.
Okay. So to make sure I'm understanding you correctly, you don't personally have safety concerns between the child and her father, and that child has already spent multiple weeks visiting her father without problem, correct?
Correct. Yes, sir.
All right.
The only concern I have with that would just be, I guess, helping me understand the visitation rights as far as pickup and going. I think that's the only thing we came in complications with.
But you have no objection to a standard possession order?
Oh, no, sir, I don't. Not at all.
Thank you very much. No further questions of this witness at this time, Judge.
All right, ma'am, and to answer your question, under Texas law, the visitation pickup and drop off, the beginning of visitation, the non-custodial parties to pick the child or children up from the custodial party's residence, and at the end of visitation, to return to that residence. And that's the way it goes so long as everybody remains where they are. If you move to another spot, say you move to LA, California, then it changes from him having to pick up in LA, but you having to pick up at the end of visitation because you're the one that moved. Okay, but for right now, all visitation, pick up and drop off would be at your residence. Understood?
No question, sir. He's in another state. That's the only reason why I was asking that.
Yes, ma'am. I figured that.
So it would be him picking up in as far as my residence here to where I'm at this state and basically drop off in my state.
Yes, ma'am. That's what the law requires going forward. So long as you live in this county, you're a Bell County resident. So long as you live in Bell County going forward, that's his responsibility.
Okay. Yes, sir.
And
Thank you for
different packages to set up visitation where he actually has to pick them up, or he can set up through buying airline tickets ahead of time, having you take the child out to either Killeen or Austin to fly out to meet dad, and then picking the child up at the airport at the end of visitation. But that's something we can talk about later. All right.
Yes, sir. Thank you.
All right. All right. Anything else on your mind, Ms. Thornburg?
No, sir. I mean, pretty much this is summing it up.
All right, then. Mr. Strong, any other questions you have before the state gives you the matter of your case?
she's been here more than twice. I'm sorry. She's been here more than twice. She was here in 2020.
Okay, so stop.
Well, I'm saying though, like that was a false statement though. It's a false statement. My child's been here more than twice, sir. That's what I'm telling you.
Okay, well, sir, again, it doesn't change the factor that she said it's okay to have standard visitation. Okay, so that's what we're looking at doing. Okay, all right, Mr. Green, you can any questions of Mr. Strong about his number to dependents and how he has those dependents set up at this time? Thank you.
State would like to recall Mr. Michael Strawn.
All right, you may proceed.
Mr. Strawn,
Yes.
stated that you have 5 other minor children, correct?
Yes.
And what are the names and ages of those children?
Oh. So you got his name's Josiah McKinney Strong. Josiah is 13. DNA test on him. You got Michael Strong the third. Gianna Strong. I have Malachi Strong. All these kids that I took DNA test for.
Okay. So right now, that was, you named 4, I think. You said the 13-year-old, then Michael, then you said Deanna?
No, I said Josiah is 13, Michael is
Right.
7, Gianna is 5. Yes, sir.
Oh, Gianna. Okay.
Gianna,
Gianna.
yes, sir, with a G.
Okay, with a G. Okay. And who's after Gianna?
Gianna is her name is Michaela. That her.
I'm sorry, you cracked up. I'm sorry. Yeah, the connection's not that great. Right now, I've only got 3 kids.
Yeah, I'm in the mountains. I'm in the mountains. That's why I'm in the mountains working. I apologize.
I understand. But right now, I got 3 children. I got the 13-year-old, I got Michael, and then I got Gianna. And where's there's a 4th?
You got Malachi.
Malachi. And how's Malachi?
Malachi's 3.
Okay. All right. So, and this child makes the 5th one overall? The one in this case?
Harmony. Yeah, should be 5. Yeah.
Okay.
And then my 6th child, she'll be 19 in January, but I don't think she matters because she's not a minor.
Yeah, she's grown. So, yeah, that doesn't count. All right. And so you say you guys, I understand the testimony, there's DNA on at least 3 of these children, correct?
Yes, sir.
Okay. And the 4th child, how's that one established?
He lives with me. I'm engaged to his mom.
Okay. And that's the
Back-end index pointing right. Now we're getting into the numbers, and child support calculations can surprise parents. The system looks at total dependents, not just one child.
3-year-old?
Yes, sir.
All right. And you have a copy, and you're on the birth certificate, correct?
Yes, I am.
All right. All right. For final hearing, sir, we'll need to get copies of either those DNA tests or those orders that say the older 3 children are your legal children, and we'll need to get a copy of the birth certificate of the child that you're engaged to. I'm sorry, the child that is 3 and that you're engaged to his mother. So if you get a copy of that, so that'll confirm all that. All right, but we'll save all that in the final hearing, sir. But we'll get those verifications for a final hearing and take it from there when we come back after the DNA tests are back. You may proceed with any other questions, Mr. Gwynn.
Yes, sir.
I have no further questions for this witness at this time, but I can provide the court with those numbers anytime.
All right, you may go do so at this time. Thank you.
All righty, I just reran that calculation based upon a monthly gross of $3,000 a month, and for 1 in and 4 out, that's going to come out to a guideline child support of $349 with a guideline medical support of $23.
All right, folks, that's what I'm looking at doing on a temporary basis. I'm going to go ahead and order the DNA test. I'm going to go ahead and Mr. Strawn order you to also, like I said, as well as the documentation for the children that are still under the age of 18. You will need to provide a copy of your 2025 W-2 form for the state for us to do this on the final. And at this time, I'm looking at going ahead and setting this up as a temporary order, ordering temporary child support and temporary cash medical starting the first day of March. When we come back to the final, the court will look at, in accordance with any pleadings, retroactive child support, back child support. The laws of the state of Texas, we can go back up to 4 years automatically. And the court rarely goes beyond that 4-year time frame, but it's something we're looking at. And again, you'll need to provide that information confirming the children and the income. And at the final hearing, we'll look at setting that up as a final and as a temporary hearing. As far as the temporary order is concerned, I will go ahead and order temporary standard possession order, which means visitation going forward, older child. But again, sir, it's your responsibility to pick the child up from mom and drop the child back off until further order of this court. So with all that thrown out at you guys, and you get ready to get an order that's going to be about 15, 16 pages long that says all this, I'll start with you, Ms. Thornburg. Are there any questions at this time, ma'am? Anything else you think I need to add in your temporary order?
No, sir.
All right, Mr. Strong. Anything else, sir? Anything you think I need to add in your temporary order?
Yeah, I get money taken out for child support now, and you're going to take this. So the temporary order is including my $3,000, correct? That's what you're saying, right?
Yes, sir.
Okay. Well, what if, so I don't bring that home if I already have withdrawals coming out?
Yes, sir. We gave you, see, under Texas, we don't look at
That's what I'm confused about.
Okay, Texas doesn't take out for child support you are already paying for some other kids. Texas gives you a percentage credit for the other children you have, and that's what the state has done. You've got 4 children in, 1 out, so that percentage is based on that amount. If you only have this one child, you would be ordered to pay child support at 20% of your net income for this one child. But however, since you have 4 other children, we have calculated that and given you the correct percentage for those 4 other children. And Mr. Graham, what is that percentage, just so Mr. Strong can be aware of it?
So allow me to look. Also,
if I get an attorney, go ahead, never mind.
I'm sorry, I cannot hear what Mr. Strong
No, I
said.
said never mind for now, but go ahead and just give me the percentage, please.
Nothing. I didn't say nothing, sir. I didn't say anything.
So for 1 in and 4 out, that's going to come out to 13.6%.
All right. All right, sir. It's not the best in the world, but when you got that many number of kids, that's what the law says you're entitled to auto pay child support of 13.6, and that's where that came from. Any other questions, Mr. Strong?
All right. Thank you so much. Not at all.
Right.
Thank you, guys. Thank you.
All right, Mr. Strong, I'm going to give you a date in the future when we're coming back. I'm going to order everybody to take that DNA test as soon as possible. We're dealing with a multi-state thing, so I'm going to probably set this about 10 to 12 weeks out. So let me look at my court dates coming up on the general docket. This is February, so let's go into March, April. I'm going to look at May. That way, I know we'll have plenty of time to get those DNA test results back. So I'm looking at, let's see, the first Tuesday in May, Cinco de Mayo. All right, I'm looking at resetting this case for Cinco de Mayo, the 5th of May. At 9 a.m. on the Zoom docket for that date. So is there a problem with that date for either of you? And I'll start with you, Mr. Strong, and then I'll go over to Ms. Thornburg. I know you got it, sir. I'm giving you plenty of notice and plenty of time out so you can be ready to go on that date. Is there any problem with the 5th of May Zoom docket, sir?
I should be able to. I got a baby due that month, but I should be able to.
Back-end index pointing right. That last warning is serious. Retroactive child support can reach years into the past, meaning today's hearing could affect financial obligations going way back.
All right, good. All right. If you got another child due that month, sir, if you can show the proof of paternity of that child, we can look at that child at that point. But until the child's born, I can't look at it.
No, I'm just saying, like, if the baby's born, then I probably won't be present to the court hearing. What I was saying, sir.
All right, well, sir, you need to, it's a Zoom hearing, so no matter, you sit in the waiting room waiting for the baby to be born, you can appear. So do not show up. That's when bad things happen. All right.
Yes, sir. I have an attorney. It'll be fine. I understand. Yes, sir. I understand. Yes, sir.
All right, thank you. All right, Ms. Thornburg, any problem with Cinco de Mayo?
No, sir.
All right. All right, then, folks. I'm gonna go ahead and reset that to that date, Mr. Gwynn. I'm gonna go ahead and set the temporary order based on the number of children that are here right now. And again, at that hearing, did the state ask for retro in this case?
I'm holding that in abeyance for the time being because Mr. Strawn does not currently have access to the documents he wants to present to the state.
All right, then. Well, we'll go ahead and I was going to hold that in advance anyway, but Mr. Strong, there's a chance that this court may order back child support for the last 4 years based on the circumstances, but we'll wait for the testimony on that at that time. So at this point, folks, I'm going to let the state prepare this temporary order, send out the reset dates of the order for paternity testing, and I'll see both of y'all. Either I'll see you or might be another judge on that date. But because the judge is looking at getting a knee replacement. So yeah, so that might be the date I'm gone, but we'll see about that at that time. So anyway, but no matter what, there'll be somebody here to take care of your case. Yeah, thank you both very much. Everybody be careful out there, and may the parties be excused. Mr. Gwynn, or you want them back in breakout?
If I could have them back in breakout, I should have this temporary order in front of them very quickly.
All right, folks, the state's going to put you back in breakout.
I got to go to work.
All right, sir. Well, whatever it is.
I have to work. Like, I'm behind. And do I have to stay? I have to work.
Sir, stop.
That's what I'm asking. Like, do I have to stay?
You don't have to. You just say, sir, you can see. The court understands you're at work, sir. You're free to go. All right, thank you. Mr. Gwynn, just send it out to her. Make sure you go. Do you have his email address confirmed where to send this, Mr. Gwynn?
I do, Judge. And Mr. Strawn, if you wouldn't mind, just be vigilant. Yes, it will be in your email via DocuSign before the end of today's.
Yes, sir.
Yes. Thank you very much.
I'll make sure I check mine today. Thank you.
All right, thank you.
All right, Mr. Steinberg, go back in the breakout. You'll get a copy of this and get the sign off on it before you get out of here. Thank you, ma'am, very much. And we're off the record.
And Mr. Strawn, if I heard you correctly, yes, you are free to leave.
Okay, thank you so much.
Thank you.
All right, I'm going to finish writing this one up. It's now 1:30. I'm probably looking at doing a lunch break. Is anybody else ready to go on something that's very, very brief?
Not that I'm aware of, Judge, but I can go verify that.
Okay, verify that before I get out of here, but I'll plan on taking a break in about 10 minutes.